record button. So sharp after 1 minute, sir, we can start the session if you permit us.
Sorry.
Sir, it's sharp 6 o'clock. Can we start the session, sir?
Please.
Good evening and a very warm welcome to all of you to the webinar series hosted by Advocates Association Bengaluru in association with Advocates Academy Bengaluru. Today we have with us Senior Advocate Shri P.S. Rajagopal sir with us, and he needs no introduction, of course. And this is not a new forum where sir is presenting topics. Even during COVID and post-COVID, we have had several sessions for Advocates Association. Mr. P.S. Rajagopal is a doyen in the service arena, a specialized branch of law. And sir is one among those senior advocates who have extensively practiced on on service front. Sir, it is both privilege and honor to have you on this forum. On behalf of Advocates Association, on behalf of Academy and my personal behalf, sir, I extend a very warm welcome to you.
Thank you.
Over to you, sir.
Esteemed office bearers of the Advocates Association Bangalore, which is the largest bar association in the country. Esteemed office bearers of Advocates Foundation, perhaps the only initiative in the entire country to provide a forum for continuing education for the advocates. Mr. Trivikram and my colleagues. I have been speaking in webinars hosted by different organizations all over the country, including by one forensic science university. But when I stand before you or sit before you, to be more appropriate, feeling is totally different, because apna gar to apna hi gar hai. That is, it is after all my home, and it gives an extra pleasure. When I was asked to speak on service law, for the first time, I thought, why this designation or labeling as service law? Because basically it deals with employment law, or more precisely, non-employment law. Normally, an employee goes to an advocate when he is non-employed, in the sense he has been dismissed or punished or compulsory retired. This concept of the phrase service law, if we understand this as practitioners of law, it would be a great guide in our endeavors to get justice to the employees. Ultimately, this is a branch of employment law. A person is an employee, whether he is employed in private sector, whether he is employed in a factory, or whether he is employed in central government services, or whether he is employed in state government services. And within the private sector, whether a person is employed as workman or whether he is employed as non-workman or a managerial employee. In all these cases, it is a question of employer-employee relationship, or predominantly snapping of the employer-employee relationship. Therefore, broadly, I would categorize the entire law dealing with employment, then various facets of employment, that is, commencement of the relationship, from recruitment notice, then selection process, selection, appointment, probation, confirmation, then promotion, disciplinary proceedings, suspension, retirement, and post-retirement. For under every employment relationship, there will be two of the terminal benefits which we get after we cease to be employees. The components of the employer-employee relation or employment law is one and the same. While working, it is salary. Post-retirement, it is payment of gratuity or provident fund or pension, as the case may be. But all employer-employee relationship or facets of employment law are not one and the same. Broadly, we have private sector and public sector and the government per se. If you keep aside government per se, to which industrial legislations like Industrial Disputes Act or even Payment of Gratuity Act does not apply. In rest of the relationships, the relationship can be broadly classified as one governed by contract and another governed by labor laws. The difference is this: if a workman is dismissed from service, it is undoubtedly, if it is contrary to the terms of employment, it is definitely a breach of contract. But the remedy which a workman employed in a private sector or even for that matter in public sector is different from what a corresponding employee in public sector gets. Suppose let us take a tax collector in a municipality. It is a statutory employment, though it is under public sector. Or take the case of a sales or an accounts clerk in private employment. He would be a workman under the industrial jurisprudence. The difference in the relief that one can get is, if a non-workman who is not governed by industrial legislation, if he has to get relief against wrongful termination, he cannot get reinstated in employment, or he cannot get a declaration from anybody that the employer-employee relationship is subsisting. That branch of law, we call it as pure and simple contract law. Irrespective who is the employer, as long as it is not a statutory body, as long as it is not a governmental employment, it is governed by contract law. But the relief that such a person can get differs. Under contract law, the forum for you is civil code, and section 4 and section section 14 and 41 of the Specific Relief Act. Section 14 prohibits or bars specific performance of an employment contract. Section 41 declines the relief of injunction. That is, if contract of employment is terminated, it cannot be specifically enforced. Therefore, Section 41 provides that if I cannot restore the contract of employment, I cannot also prevent breach of contract of employment. Therefore, Section 14 and 41 ensures that a private sector employee who is not a workman, he cannot get the relief of reinstatement or a declaration of subsistence of the contract of employment. That is purely now coming under the employment contract. That is one branch of law. This is one branch of employment law. Second branch is where a person is governed by Industrial Disputes Act. He can be given declaration of continuance of service and restoration to service under the industrial jurisprudence, that is under Industrial Disputes Act. That branch of law, we call it as labor law. A case arose before the Supreme Court in Premier Automobiles. Some of you might have seen me quoting this judgment also. A workman from Premier Automobiles, he was dismissed. He approached the civil court. Under the industrial law, the employee is entitled for reinstatement. But under civil law, he is not entitled. Then the matter, when it went to Supreme Court, what the Supreme Court said was this. Yes, choice of forum is available to the employee. He can go to civil court or he can go to industrial court. But relief of reinstatement can be granted only by industrial court and not by civil court. And in the process, it declared a law. If an enactment gives you a right, and for enforcement of that right, the enactment also creates a forum. You can go only to the forum created under that enactment, which gives you that right, and not to civil court. So even if an industrial workman goes before the civil court, all that he will be able to get is declaration of wrongful breach of contract, and for that, what is the relief? Relief of damages. But if he goes to the labor court, the labor court can say that termination of employment is bad and it can reinstate the employee. And then the service law where writ jurisdiction is available. Therefore, we have broadly three branches of employment law, and one of those branches is called as service law. It is not that the moment you are a practitioner of service law, you can file writ petitions on behalf of everybody. No. Service law is that branch of law applicable to non-workmen or applicable to establishments where Industrial Disputes Act does not apply. For example, if you take government service, entire Industrial Disputes Act itself is not applicable to it. Don't say that government is not an industry. It is not an industry as defined in Industrial Disputes Act. But according to me, in a welfare state, government should be the most industry. It all depends on the definition. Now, for example, we have private educational institutions. In private educational institutions, relief of reinstatement can be granted, though in respect of a private educational institution, even though the institution itself is in private sector, it is not an instrumentality of state, it is not a statutory body. Relief of reinstatement can be granted by the Educational Appellate Tribunal, not because of anything, but because of the provisions of the Education Act. Just 2-3 days back, I have argued a matter and I am awaiting the judgment on this. Teachers from a private unaided education institution approaches the writ court, seeking a writ to reinstate them into service. It was one of those rare cases where I appeared for the management. And my argument that I have advanced before the court is this. In private employment, no question of reinstatement. You can declare the termination to be bad but you can grant only damages. Relief sought by the employees here is that they should be reinstated. This is a remedy that cannot be granted by a writ court. Relief of reinstatement is permissible under Education Act. Therefore, if these petitioners want reinstatement into service, the only forum is forum created under the Education Act and not under Article 226. This flows from Premier Automobiles. Therefore, when a aggrieved person, I would not call either aggrieved employee or aggrieved manager or aggrieved workman. It is for you to determine whether in which category he falls. Approaches an advocate and says, look, this is my service problem, or this is the problem that my employer has created, and I am an employee. This has to be taken up. Then the first and foremost thing to be assessed by us is which of the three forums is the appropriate, which of the four forums or five forums that is appropriate for us. Because that is where our journey begins to redress the injustice perceived. I use the word because perceived because employee may feel that he has been unjustly treated, but ultimately the court may determine that there is no injustice caused. The perceived injustice or perceived grievance of the employee, first thing is, which is the forum. Compare this with property law. Say land is acquired, irrespective of who acquires, who has acquired the land. Because one thing is, only state can acquire the land. Irrespective of whose land is acquired, the forum is only challenge to the land acquisition proceedings in a properly constituted writ petition. Or say you have a dispute regarding the compensation paid, definite and defined remedy of reference to the court, and you take the contract, breach of contract, irrespective of who has breached the contract, except in some rare and exceptional circumstances where the Supreme Court has said that even a contractual obligation of a government can be enforced through writ jurisdiction. Otherwise, generally and normally, the remedy is civil court. Like this, if somebody wants a divorce, remedy is family court, irrespective of who are the personalities involved. The speciality of this employment law is that the forum and the relief would depend upon who is the employer and who is the employee. This is employer specific, employee specific, and the reliefs we are entitled to get is also totally different in each of these forms. That is why the service law label has come. Service law deals with the employer-employee relationship of that particular segment of employment, which is either under a statutory body or a body owned and controlled by the government or by the government itself. Therefore, a service law, employment law practitioner will have to be practicing in all these fora and first choice of the forum. Then one peculiarity of this service law is it is rule specific. What is the rule specific thing? Say the breach of agreement of sale is there. Irrespective of the parties involved, suit for specific performance is the relief remedy. But here, the law governing is the rule made by the employer, which is most of the times not available even on Google. Because now Google I am referring to, because it is supposed to be an ocean of information. But you go to specific rules, service rules, even with respect to the BDA or BWSSB or Urban Water Supply Board, whatever it is totally untraceable on the web, notwithstanding RTI Act and specifications made in the RTI Act. What are the things that are required to be web hosted? Service rules are rarely available, and even when available, they will be either outdated or they will be either they will be rickety and not full. Therefore, the first difficulty we find in either labor law or in service law is, what are the standing orders governing the company? Then if it is service jurisprudence, what is the enactment under which the statutory body employing you has been constituted? What are the provisions of that act? Then what are the service regulations or rules made under that act? If it is government, what are the rules applicable? I will tell you one very, it may look silly, but one silly example or a very relevant example. Now, under the general recruitment rules governing employment in government, if it is a promotion by selection, there is a circular or OM issued by the Department of Personnel and Administrative Reforms, which lays down how the assessment of merit will have to be made. In the last 1 year, I came across at least two of the employees under the government department coming without the rule. When I asked them, which is the government order that governs this selection procedure, they were not able to answer. Unfortunately, we have the government, not only our state government, even the central government. They have stopped publishing their own rules. Say about 20 years ago, you would have got circulars, government orders issued by DPAR for 1 year. It will come out as a book. Then guidelines under CCA rules, it will come out as a book. Now it is not coming. Tracing the rule is the first difficult task, which is peculiar to service law. There, what we need is there are various departments. They are normally referred to as Chitraguptas. Birthar advocates, if they come and say that, sir, this is the issue, which is the rule, that will be my natural question. Then they will say, sir, ಇವರು ಗೊತ್ತಿಲ್ಲ ಆ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಒಂದು ಚಿತ್ರಗುಪ್ತರಿದ್ದಾರೆ ಅವ್ರನ್ನ ಕರ್ಕೊಂಡ್ ಬರ್ತೀನಿ. Now it has become so difficult to trace the rules. And first task of, after ascertaining which is the forum, the first task of the advocate is to find out the rule, because entire service jurisprudence is based on the rule that governs the particular issue. And what the writ court will do? Writ court will enforce the rule, and you can get a relief from the writ court only if you point out two things. What is the rule governing? And what is the breach that has been committed? And third is, in some cases, it has to be established as to how prejudice has been caused by breach of that rule. Why, for example, even in criminal law, we come across this problem. Prevention of Corruption Act. Sanction to prosecute can be granted only by an authority competent to remove the public servant from service. Government, there is no difficulty, at least there is CCR rules having a schedule and all that. Take the case of public sector banks. The schedule is not common to all the public sector banks even. Each bank has its own regulations, which the Nationalization Act requires them to publish in the Gazette. Gazette is supposed to be noticed to whole world, but it is not noticeable anywhere in public libraries. Therefore, the first and most difficult task in framing a suit or claim statement or writ petition whatsoever is ascertainment of the rule, ascertainment of the authority in which the power is vested, ascertainment of the stipulated procedure. Please remember one thing. The certiorari jurisdiction is not to test the correctness of the order passed by the employer. It is only to test correctness of the procedure followed by the employer. In fact, in some of the judgments of the Supreme Court, I have noticed that certiorari is concerned with the procedure. We are not here to ensure that after following the procedure strictly in accordance with law, a correct decision is arrived at. What it says is that correctness of the decision is not normally available for judicial review unless in those cases where it is shocking the conscience of the court. This is therefore the ascertainment of who is the authority, ascertainment of what is the procedure stipulated. It may be for, say, even starting from adverse remarks in the annual confidential reports, or denial of promotion, or denial of employment, or placing a person under suspension. In all these respects, it is the rule which governs ultimately the right of the employee. Therefore, ascertainment of the rule and ascertainment of the authority is most important. Some of the very funny things I have witnessed in our own court. For example, you see, the state government has evolved a policy of transfer for its employees. It lays down this is the minimum tenure. Then, if that minimum tenure rule has to be breached, who is the competent authority? All that. And there are certain public the instrumentalities of the state, like KEADB or KPTCL, which have adopted the state government policy of transfer. Then one sentence in that policy is that for any premature transfer, Chief Minister's prior approval is required. There are writ petitions filed in the High Court in respect of KPTCL employees saying that for premature transfer, Chief Minister's prior approval is not obtained. And strangely, in some cases, that argument has been accepted and relief has also been granted. Chief Minister is not Chief Minister of the KPTCL. When the word Chief Minister is used in the government policy, when it is adopted by any public undertaking, Chief Minister is replaced by the corresponding authority in that organization. This is how the phrase mutatis mutandis will have to be applied. When one of the cases I pointed out that they said Chief Minister has approved. My argument was that Chief Minister could not approve because it is not a governmental employment. It took some time for the court also to see there is some meaning in what I am saying. Ultimately, when the court found that yes, my argument is correct, then it was about my client was closer to retirement, and they said, in one thing, ಅದಕ್ಕೇನು ರಾಜಗೋಪಾಲ್ ಇದಕ್ಕೆ ಟ್ರಾನ್ಸ್ಫರ್ ಆರ್ಡರ್ ಕ್ರಾಶ್ ಮಾಡು. Therefore, understand the rule, analyze in its application to a particular establishment how it should be interpreted. Then you can formulate a proper petition and seek the relief also appropriately. This is one significant aspect of service law, in as much as schedule of authorities and substance of the rules vary from employer to employer. And even in the governmental sector, it varies from one organization to another organization. Though it takes 2 days or 3 days or 4 days to locate the rule and locate the authority, please do that as a first step before we formulate the writ petition. Otherwise, we will come to grief later. Though Order 6, Rule 17, you can apply and seek amendments and all that. If we have made one wrong assertion in the writ petition, that will be a noose around our neck, which we cannot overcome even by way of amendment. Then another important aspect of service law is this. There are certain hard facts of life. One curse normally in my childhood, when I was just going to school and all that. If somebody wants to curse another, he would say, ನಿನ್ನ ಮನೆ ಮೇಲೆ ಒಂದು ಸಿವಿಲ್ ದಾವ ಹಾಕ್ಲಿ ಯಾರಾದ್ರು. ಯಾಕಂದ್ರೆ ಸಿವಿಲ್ ದಾವ ಹಾಕ್ಬಿಟ್ರೆ ಅದು ಇನ್ನು ಆ ಜನ್ಮ ಜನ್ಮಾಂತರಕ್ಕೂ ಅದು ಉಳ್ಕೊಂಡಿರುತ್ತೆ ಅಂತ ಹೇಳುತ್ತೆ. Yes, there may be truth in it or there may not be truth in it. I am not on the truth. But in respect of property right, even if litigation takes 30 years or 40 years, at the end of it, we can get a declaration that I am the owner. And the right flows from generation to generation. The right to sue survives. But look at the service jurisprudence. The service span, say earlier, I say prior to 1990 and all that, it used to be normally about 33 to 35 years. That is why pension rules stipulated maximum pensionable service as 33 years. A person would join service at the age of 25 and he would superannuate at the age of 58 those days. 33 years is the normal span of service. Today, where we have come to, maximum age for applying to, in answer to an advertisement issued by government or governmental organization, now is 35 years. And all of you are aware that if an advertisement is issued today, the recruitment will fructify into an appointment only after about 2 months, 2 years, not earlier than that. 2 years if you are lucky. Sometimes it can take 12 years also. Because 2012 recruitment notification of inspectors of motor vehicles, it fructified into appointments a few months ago. Then say at the age of 38 is the maximum age for applying for the appointment, seeking appointment. At the age of 45, you are appointed. At the age of 60, you retire. Total service span is 15 years. Suppose somebody is denied a promotion and he challenges it. If the petition is not decided in 4 years or 5 years, then naturally what he gets as a writ at the end of the litigation is, or I can say, esoteric satisfaction and not a substantial rendering of justice. Therefore, time factor is very crucial in service law. I don't blame the courts. Yes, courts take their own time. There are justifications why delays occur in court. Bench can blame the bar can blame the bench. So many things. I am not here for that blame sharing. Let me only impress upon this fact of life that if an issue remains in the court in respect of a service dispute, the ultimate remedy that an employee gets will be no remedy at all. And in some cases, this has been on the increase, unfortunately. By the time the matter reaches Supreme Court, already 7, 8, 10 years would have lapsed. And Supreme Court says, yes, you may be right. The person aggrieved may be right in his perception. But should we disturb the appointments made 10 years ago? Now, irrespective of who is to be blamed, it is a fact of life. Therefore, what is the extra care that we as service law practitioners should take? Keep the issue simple. You may have 100 grounds to challenge an order. Straight away, take the simplest of the grounds. You argue that ground only. Take relief on that ground only, so that the court will not be reluctant to hear you. Litigation would be shortened, and during the service time of the employee, he will get some relief. Otherwise, what happens is in the matters of promotion, seniority, and these things, dismissal is something different, because dismissal, he goes out and thereafter he is not bothered about what is happening in the establishment. In case of promotion, it becomes very difficult for him to work because employee feels he has been rightfully denied promotion. His junior has been, he has been denied rightful promotion. A junior has been placed above him. And it will be a constant pinprick or turmoil for him to work in such a situation. And ultimately, he gets his right to promotion to be declared after his retirement, which I normally call as Maranottara Paramveer Prashasti. It is of that posthumous awards are of no use. Therefore, we also as law practitioners have to choose which is the simplest ground on which I can get relief. I am not saying don't plead other grounds, because if you have not pleaded, you cannot argue. But choose the best ground, which is least complicated, and hammer it out. That is one way of ensuring that the client gets the result within a reasonable span of time. If large number of issues are there and if the complicated issue is there, neither court has time to take up your case, nor the litigation is going to end in one stage. It goes forward, backward, like a monkey climbing a pole, and we would be monkeying around and not getting it. Then there is another danger, that is dangerous practice. Service seniority. It is a issue that would arise very frequently. seniority list is questioned. Now, what is the law? Law is in any administrative order. If the administrator has committed an error in a certiorari proceedings, normally set aside the order and remand the matter to the very same administrator to redo in accordance with law from the stage at which illegality has occurred. This is such a this is such a concept. In the year 1990, I was arguing a case of equation of post of a cartman in agriculture department. There was a designation in Madras state. That designation was cartman. There was no post of cartman in Mysore state, erstwhile Mysore state. Then in the reorganization of states, when it came to equation of posts, certain principles were evolved. 1/11/1956 is the state's reorganization. Cartman from Madras presidency comes to Mysore state. Then he is equated with some post. His seniority is fixed. In the year 1992, I argued the final round of litigation of his equation of post and seniority. 56 to 92. It is my good luck that he had not left the planet. He was almost on the verge of retirement. This principle of remanding, what can be done by a crooked employer is that he will go through the motions of correcting the error and come out with the same atrocious determination of seniority. One round, it is fine. By the second round, even with the depressed seniority, he would have got promotion. Then he has no interest in the litigation. It becomes purely a litigation for the advocate. Client has lost interest. Then no useful purpose will be served for him, even if he succeeds, because he knows this is the highest I can go. And in spite of this depressed seniority, I have got it. Why should we pursue it? At the same time, he is not willing to withdraw it. This remand is another area where some rethinking will have to take place in the whole system. Remand should be, my respectful submission is, remand should be only where there is some complicated question of fact to be determined. Otherwise, there should be no remand. Once it is said this is wrong, then a positive direction should be issued. Who has to go where in the seniority? Or at least 1, 2, 3, 4. This is how it has to be done. If it is not done that way, it should be straight away dealt with under the contempt jurisdiction. Now, what do we get in the contempt court? When you go to the contempt court, they'll say, right or wrong, they have passed an order. It is a new cause of action, you go and file. It's all right, I will go and file. But whether the employee will be still in service, if I have to go fight for my seniority twice in 2 or 3 rounds. These are the difficulties in service jurisprudence. And to take the blame, advocates should be ready, because even if you win, ultimately, if the employee does not get the relief of promotion and correction of seniority, he will blame you only and tell that, one thing argue ಮಾಡಿ ಗೆದ್ದು ಕೊಟ್ರು ಏನಾಯ್ತು, I still continue as assistant executive engineer. When am I going to become executive engineer? This blame taking, we will have to be ready if you are practitioners of service law. I have also taken blames, but now I'm in a happy position because no client can meet me directly. So my colleagues will take the blame. And I tell that yes, this is what is possible in court. And this is what is not possible. Trivikram is smiling because I, I always tell most of the times the relief we get is no substantial relief at all because we might have won, but it would mean nothing if it ends up in a order of remand. This is one area where, as service law practitioners, every one of us should try to persuade the courts, not by way of a strike, but in each and every case pointing out how the remand can ruin the career of an employee. Friends, these are the broad specialities of service jurisprudence. The labor law jurisprudence is totally different, and contract jurisprudence, that is also part of employer-employee relationship, is different. Now, one question arises: why reinstatement is not possible under contract of employment or an employment purely governed by, this is an old phrase which we have even now retained, master and servant relationship. The employments that are governed by the Contract Act, they are called as, even today, I don't know where from we hang on to this old phraseology, master and servant relationship. Apart from the provisions of specific relief act, the philosophical explanation given by the jurists is that you cannot force an employee on an unwilling employer. Employer does not want to see his face. Courts cannot force him on for such an employer. But why it is different under government employment? There, the explanation is this. The employment under government or a statutory body, though it commences by a contract, like any other employer, government issues a advertisement, Public Service Commission selects, thereafter the government appoints, and a contract of employment is created. Therefore, irrespective of the employer who has appointed, the nature of the employer who has appointed you, the service commences with a contract. But once that contract is made, if it is a statutory body or government, the employee acquires a status. Therefore, in service jurisprudence, we will be enforcing that status, a right attached to that status, and not a right under the contract of employment. This is the basic difference. One is that of status, another is that of pure of contract, and industrial law it is. Why the same master and servant does not apply is that industrial courts are having jurisdiction to create a new contract. The employer says no contract, the employee says I want contract, then industrial court can create a new contract. Like, for example, service conditions. Say, what should be the pay structure? What should be the policy governing promotions? What should be the holidays? What should be the working hours? These are all under normal circumstances fixed by the employer. Industrial law is different in the sense, under the Standing Orders Act, or even when it comes to pay structure, industrial courts can create a new contract of employment. Suppose the employer has appointed a person in a particular scale of pay. That scale of pay can be held to be unfair and unjust and unreasonable by the industrial court. And industrial tribunal can evolve its own pay scale for that employee. These are the three different things. One is service law is status based. Labor law is based on the principle that industrial courts can create a new contract or alter the terms of contract, and it can grant reinstatement. And civil court, which is purely enforcement of contract, subject to non-enforceability of service contract and non-injunctability of a proceedings initiated to terminate the contract. These are the basic differences. All of these deal with employment law only. And when you are dealing in service law, you should know the employment law. And ultimately, you may say, I don't go to labor court. This is the appropriate remedy. I don't go to labor court. There is nobody in my office who can go to labor court. Therefore, go to an advocate who is practicing labor jurisprudence. Or if it is a question of enforce, declare the contract and damages, we can say, civil court ಹೋಗ್ಬೇಕ್ರೆ ಯಾರು ಹೋಗ್ತಾ ಇಲ್ಲ, please go there to an appropriate advocate. This is what I thought fundamentals of practice means. Fundamental problems, fundamental things we have to understand. Like any other branch of law, this is a vast law, and most importantly, there is one concept called as concept of fairness. What is fair? Invariably, you will find that fairness is not defined. Fairness can be perceived, or or to put it better, unfairness can be perceived. But what is fairness cannot be defined. Therefore, the commonly occurring repeating phase is in the facts and circumstances of the case. Natural justice, violation, whether it has caused prejudice in the facts and circumstances of the case, whether an employee has been dealt with unjustly in the facts and circumstances of the case, whether the employer is justified in his actions in the facts and circumstances of the case. Most of it is the ultimate judicial determination would be relatable to facts and circumstances of the case. That is why we say service law is judge-made law and not book-prescribed law. This is another problem with the service law practice. You may ask how you have tolerated all these problems. I have tolerated and I have grown with that. Thank you very much. Yes, Trivikram.
Thank you, sir. That was a very informative presentation for a advocate to begin, and these fundamentals are very important. Unless the fundamentals are clear, we will not be having clarity on any particular topic. And that's the whole agenda of we having this particular topic on this forum. And now we'll keep it open for the Q&A session. So anybody has any question, kindly post it through the Q&A box, or you can also hit on the hand raise button. So I would be unmuting you. I repeat, if anyone has any question, kindly post it through the Q&A box, or you can also hit on the hand raise button. I will unmute you so you can directly post the question to the resource person. That's it for today, sir. Sir, once again, sir, on behalf of Advocates Association Bengaluru Academy and my personal behalf, sir, many thanks to you.
Thank you, Trivikram. Thank you.
And we would await for that book on service law, sir. I think somebody has a question. I think.
Yes.
Madam Sinchana, do you have a question?
Yes, madam. You have anything? No, unmute, unmute.
I have given you the option to unmute.
No, I'm a colleague of senior only, so I'll be always with my senior only. So no. That's okay.
So you are so lucky.
Yes, yes, we are so lucky
All
to be
right, madam.
juniors.
Thank you.
Thank you.
Thank you. Thank you so much, sir, once again.
Thank you. Thank you.